You're listening to the Unsiloed Podcast with Greg LeBlanc, produced by University FM. Unsiloed is a series of interdisciplinary conversations that inspire new ways of thinking about our world. So wherever you are, enjoy today's episode, and here's your host, Greg LeBlanc.
Welcome to Unsiloed. This is Greg LeBlanc, and I'm here today with Melissa Jacoby, who is a professor of law at University of North Carolina in Chapel Hill, and also the author of this book, which just came out. It's called Unjust Debts: How Our Bankruptcy System Makes America More Unequal. Welcome, Melissa.
Thanks very much.
Okay, so I think my loyal listeners might think I'm a bit obsessed because I think this is the third podcast that I'm doing out of 500 or so that is about bankruptcy. And for me, bankruptcy is one of the most fascinating areas of law because it touches on almost every other area of law at some point. And so you've got these bankruptcy judges that are effectively making judgments on tort claims and contract claims, labor disputes, and everything, which is super fascinating. And it's also something that I think is uniquely American. Americans have really perfected this thing, and people from all over the world come to America to, file for bankruptcy. And so I guess maybe before we jump into the book itself, maybe you could tell me, what drew you to bankruptcy? Why did you find it fascinating? And does our fascination with bankruptcy make us weird, or is it a logical fascination?
One way to think about maybe what should happen to bankruptcy in light of your very great question is make bankruptcy boring again. One thing that does make it interesting to you and to me is that intersection with absolutely everything. In America, it's also pretty common that one person, whether an individual, a human, or a corporation, or even a government, could have lots of different kinds of creditors and not enough money to go around and needing some sort of collective resolution. So it is in conversation with so many other policy issues, and that absolutely is a big part of what fascinated me. It's also then a reason that I became very concerned also about the system, very well-meaning, and yet that's a lot to put on one system to juggle all those different considerations.
Yeah, and it's interesting that the same statute, right, the same body of law applies to both individuals and corporations, or real people and fake people. And I think the thrust of your work is to highlight how the code and its different effects has maybe an unjust impact. In other words, both in personal bankruptcy and in corporate bankruptcy, there may be some consequences which were unintended and perhaps undesirable.
Yes, I will say that comparing fake people and real people seems to make a lot of sense to people in the real world. And this book was written for a broad audience. That was at least the aspiration. In the scholarly universe, and in particular the legal scholarship universe, the idea that one would compare fake and real people in bankruptcy, some of my academic friends think that's not even an interesting question. I do think it's an interesting question because while it is true that in other countries, personal bankruptcy and corporate restructuring may be entirely different, the basic building blocks, the legal powers and how they operate in America and really to a large extent around the world come from a common core. They are trying to do similar things: a pause on all activity, canceling or modifying debt. Those are the superpowers of this system. And as someone who does study a lot of different kinds of bankruptcy cases, as opposed to only going deep on one kind of bankruptcy case, some might say, well, maybe it's a little less sophisticated because it doesn't go as deep, but I'm going wide. And I think that reveals some things, some forms of unfairness, that why should a system be less generous to humans than it is to big corporations? I think that's a fair question to ask. I don't always know all the different ways we might answer it, but I try to start that conversation with this book.
Well, look, bankruptcy law, at least personal bankruptcy, is designed to protect the honest but unfortunate person. And so when we're dealing with individuals, the honest but unfortunate people are usually the folks who are filing for bankruptcy. But in corporate bankruptcy, the honest but unfortunate people are usually the ones who are the creditors or who become the creditors. So one would think that if it's the same law, then it can't be unfair to people when they're sitting on one side versus the other, right? It should be, if it's unfair to the filers in the personal arena, it should be unfair to the filers in the corporate arena.
And I appreciate that you're looking both at the debtor and creditor element. Now, I often tell students and anyone else who will listen that bankruptcy is very much creditor versus creditor and not just debtor versus creditor. But I think that goes further to your point that in some big corporate cases, there's a range of types of creditors. Some of them are humans who haven't had many interactions with the legal system, don't have a fancy lawyer or any lawyer on retainer to help them through these matters. And I think we learn a lot about the system by asking how humans in all of these different roles fare and what their perception may be about the legitimacy of the system.
Well, maybe we'll start with the personal bankruptcy. I think you said, is it 1 million people a year file for bankruptcy in the US?
The number has gone up and down and up and down and up and down all over the place. I think one way to think about it is, as Professor Bob Lawless has put it, that 1 out of every 10 living Americans has filed for bankruptcy at least once. And that gives you a sense of the magnitude. That's just the people who have filed, not the people who are affected. And of course, big cases affect a lot more people. But bankruptcy is a pervasive legal protection, a form of social insurance, some say, in the United States. The actual rate of filing is quite variable over time, over the last couple decades.
Now, look, the whole point is to provide some discharge, to give a fresh start to individuals who may have gotten a bit over their skis. And I think you said that it was in 2005 where creditors lobbied to make full discharge more difficult. And I guess the question is, why would they do that, right? Because it seems, especially when you're talking about adjusting creditors, the ones that go into the lending relationship with complete awareness of the rules of the game, why would it matter to them what the rules of the game are? As long as they know what the rules are, then they can just adjust accordingly. So what would be the argument in favor of avoiding complete discharge and making these debtors assume the debt even after bankruptcy?
Well, it's a great question to ask the consumer credit industry. I'll give it a try to answer it because, as you say, lenders extending credit for a profit, that is an appropriate business model within reason in the United States and many other places. And they can adjust to defaults. Most of defaults happen outside of bankruptcy rather than in. And every contract in America is written with an invisible clause in it that says these terms apply unless someone files for bankruptcy. The thing that bankruptcy can do the best, or is the most equipped to do relative to other laws, is to cancel debts. So what is going on with the consumer credit industry in its many, many years of lobbying to make the bankruptcy system more complicated and more expensive for average families to use? It doesn't seem to have been that the bankruptcy system operates more smoothly and efficiently, because if anything, the 2005 amendments had the opposite effect. It created more uncertainty, more litigation, and it raised the cost of actually getting a lawyer to represent a family, which then maybe gives you more of a sense that if...
So you got to pay to actually file for bankruptcy. You got to pay court fees and you got to pay legal fees. So the folks who are probably least well equipped to pay these things are required to pay them.
You have to pay not to pay in America to go bankrupt. It is the kind of social insurance that requires an outlay of funds. And the bankruptcy system can't print money. It doesn't do job retraining. So the one thing it does is cancel debt, but you have to pay for that.
Why doesn't the government pay for it? It does seem like it is wealth enhancing. It's an efficient system. It makes sense. Why wouldn't the government pay for it? There are certain courts I know, like the SEC has to be self-funding and so forth, but why would the bankruptcy courts of all courts need to be self-funding?
Well, I don't have a great answer other than the real politics of the situation. Bankruptcy is an area that has always been pretty bipartisan in support. The basic laws that are in place from 1978 was bipartisan. The 2005 amendments, which were way more punitive and made the system more complicated and expensive, also bipartisan. And one thing one has heard, including sometimes from people like my own former professor and yours, now Senator Elizabeth Warren, has been, this is a system that doesn't, at no cost to taxpayers, that basically it is self-funded. And not only is it self-funded for the bankruptcy court, but the federal judiciary often is very appreciative of the funds that come in high filing years. So I think maybe this is a way to thread the needle of, we believe in this system, but there's a concern about making it too easy, the idea of skin in the game. Those are some of the theories, but I do think that if there was more collective agreement on the importance of this system in a capitalist society, it would not be nearly as expensive as it is today. And there might be a system where more of it was public funded, especially the parts that promote the integrity of the system. Because by making the system so self-funded, this comes up even more in big business cases. There's not enough money to do the integrity promoting investigations sometimes as there really should be, and it leads to cutting some corners. So it is something that has occupied my thoughts, and I don't have a great answer, but this is a very enduring element of the system to have people pay to participate in the bankruptcy courts.
Look, I mean, it makes sense that there are certain debts we wouldn't want people to be able to discharge too easily. Student loans, great example. Otherwise, there would be no student loans because everybody would just file for bankruptcy immediately upon graduation. And then,
well, they probably wouldn't, but I take your point. For at least for government guaranteed loans, the government's protecting the public fisc so that there's money for other loans. But your point about moral hazard is always part of this conversation.
But also, I mean, we know that reorganization makes sense for corporations. And the problem with humans is that we can't give our creditors equity in our future earnings. That's called slavery. So, if we can't provide equity in the future enterprise, isn't this kind of affirmation of debt after bankruptcy a backdoor way of doing like a Chapter 11 for people? If you do Chapter 13, isn't that kind of why you would do this?
Well, one of the points I try to make in Unjust Debts is that there are two paths of personal bankruptcy in the bankruptcy system, which adds to the complexity and the expense. The one you just mentioned, Chapter 13, is set up in a way that it costs more to access than the simpler kind of bankruptcy. And there are a few more tools in there for a debtor with a home mortgage to be fixed a bit, or a car loan that needs to be gotten back on track. But the catch is that, well, you've paid more and you're giving all your future income for 3 to 5 years. And if the person stumbles and can't fulfill the plan, and that's often life in America, there are a lot of risks that families of modest means endure, then often the individual doesn't get any debt relief at the end. All the debts come roaring back with all the interest and fees that accumulated in the meantime. That doesn't happen when corporations get their plans confirmed. They get an immediate discharge. And then even if within a year, the company says, oops, we did not predict properly how things were going to go. Rite Aid recently emerged from bankruptcy, is talking about going back in. Mallinckrodt, opioid provider and manufacturer of other drugs too, was $1 billion short just a year out of bankruptcy. So the fact pattern that you raised just is one of the key examples of how fake people and real people are treated differently in the system. But then we get back to, why does the credit industry tolerate one without the other? We're sometimes talking about different sets of actors, but some of it also has to do with how humans are distrusted and the value judgments on humans in this system. And then the very particular interests of those who are most invested in consumer credit, and whether the complexity of bankruptcy can keep people out who are likely to be making minimum monthly payments forever, basically, because it's too expensive to get into bankruptcy.
We also talked about government fines and fees and how these things are very difficult to discharge. That seems part of the general trap that poor people get sucked into. You get a ticket and then you don't pay the ticket and then you lose your driver's license and then you get a ticket for driving without your driver's license. And the next thing you know, you're in jail and you're fired and everything just gets worse and worse. And bankruptcy is supposed to be maybe a way to pull the plug and reboot, but it sounds like you can't even reboot in that way and get rid of these fines. So are governments sort of to blame, some of these local governments that impose these things? I know this is separate from bankruptcy a bit, but it does seem remarkable that these local governments are preying on the people who are least able to pay.
It's really important, going back to where we started in this conversation, to see how bankruptcy is in conversation with a lot of other laws and policies that create inequities outside of bankruptcy. And then when they're brought into bankruptcy, bankruptcy piles on. It adds to that baseline. So it is true and well documented that communities of color that are generally low income are disproportionately part of this fees and fines universe, where local governments try to get revenue on the backs of people who can least afford it. And the ways they try to do that are often counterproductive, because one loses their driver's license for not paying a fine. And then in many areas where public transit isn't strong, that means they're not reliably getting to work. And then we have a vicious cycle. So then the question is, where does bankruptcy come into a story like that? And this one gets me in a little bit of a rough patch, because on the one hand, the stories I explore through the book lead me to believe that bankruptcy is best equipped for debts incurred by contract. That's the original idea of it, and its highest and best use. And indeed, there are many kinds of debts I don't think should be canceled in bankruptcy. And on that, by the way, I'd say fake and real people should be treated the same, but that's not how it's going now. But for humans, for example, willful and malicious injury. But then we get to the fees and fines issue, which is having a racially disparate effect. And one of the themes of the book is about racial disparities that arise in bankruptcy, in part because of background conditions and then bankruptcy piling on. And the exception to discharging fees and fines in the bankruptcy code, it starts with, I think, a germ of an important idea that it's not part of the ordinary debtor-creditor relationship. And yet the Supreme Court expanded the interpretation of that provision so much more broadly than it was originally designed. So it's catching all of these kinds of obligations that are really keeping certain families behind and not able to get a fresh start and get ahead. So that's the sort of the quandary I see. Bankruptcy would serve a good function by, again, fresh start for these families. But how do we distinguish between the types of obligations to the public that people should not be able to cancel and those that they should, because they are somewhat indistinguishable from a credit card debt in many respects?
Yeah, I mean, I think if bankruptcy were only about adjusting or contract creditors, I don't think most of these issues would be a big problem. I think where bankruptcy gets super interesting is when we talk about these non-adjusting creditors, and particularly when you have limited liability and high leverage. So basically people are judgment proof, but is the problem there that we allow for entities to become judgment proof? That's going to be a problem regardless of what the bankruptcy law says.
Oh, absolutely. So if we're talking about entities, and when I talk about fake and real, people sometimes suggest that I'm critical of the corporate form, or I don't believe there are real people behind the fake person. Of course, neither of those is true. I think the corporate form serves very important functions in our economy, but you do not need bankruptcy to run from creditors or hide from creditors, and even, at least on the corporate side, to get a fresh start, because you could start another one. Now, that's not always possible because of personal guarantees in small business settings and the like. But bankruptcy is supposed to be an intervention that makes things better than if they were resolved in these other ways. You said something that intrigued me after we were talking about the government, and you mentioned non-adjusting creditors. Do you think of these governments as non-adjusting creditors?
No, I was thinking of tort claimants, or whether it's tort claimants or like civil rights violations, or basically innocent bystanders who find themselves victimized, and then whatever redress they might have had if they had a solvent defendant evaporates.
Yes. And so I've gotten a lot of discussion about chapter 4 in the book, which deals with civil rights in a bankrupt city. So we're thinking about city of Detroit, city of San Bernardino, California, are two that I highlight in the chapter. And these are situations where civil rights claimants, police brutality claimants, who are surprised to consider themselves creditors, that is not a label that would have otherwise been ascribed, are swept into a bankruptcy. Their other rights have been suspended to pursue other remedies. And a lot of people want something other than money, but money is how the legal system in general provides remedies. And then bankruptcy really sees it that way. They get into the case and realize that who are the dominant parties here? Well, we've got various kinds of bondholders, and the capital markets, of course, are very prominent players in these cases. We have workers and we have retirees, and they're very prominent players because this is where the big debts really are in those cases. They're the ones central at the negotiating table with the debtor. No room at the negotiating table in these cases for residents of these cities who allege and sometimes have had a judgment or a settlement that declares that there has been a wrong committed. They're not part of the negotiations. They are outvoted by other claimants, including who are grouped together, so their voices can be diluted. And then the civil rights claimants are getting among the lowest financial recoveries of any kind of claimant, and sometimes not even for a very long time. In San Bernardino, the promised payout was 1% of claims, and those people also lost their rights to pursue individual police officers who had played an outsized role in an incident. In Detroit, 5 years after the case is over, civil rights claimants still hadn't been paid, and then were told they needed to have a brokerage account in order to recover. And while a brokerage account may be a common feature of some households in America, it is not a common feature for many households in America. So you're basically saying you have to spend more money to get 3 cents on the dollar, find someone who can set up such an account, or can't really recover. So I think those cases show both that there's a very low recovery for those claimants, but it's really more than that. It just makes clear the laws just weren't written for them, but they're swept in anyway. And that the law is complicated and uses a lot of jargon, and then uses techniques and investment vehicles that many Americans are excluded from.
Well, I mean, it seems like part of the problem that you highlight is that the minute a defendant files for bankruptcy, then, the only remedy is going to be monetary. Whereas if they were outside of bankruptcy, then a civil litigation could result in injunctions or other kinds of remedies. And those are basically foreclosed. So it turns everything into money. The other problem, which I think you highlight, is that the whole discovery process and all of that is just truncated. And so if there was a desire on the part of the plaintiffs or of society to really figure out like what the heck really happened, none of that stuff is going to happen potentially.
There are areas of law that depend not as much on upfront regulation, but on ex post exploration of alleged wrongs, that the civil litigation process is not merely to reward a remedy like some people think, although, again, sometimes that is what people want. It is to switch the power dynamics and the control, that an injured person gets to ask someone else questions, gets to shape the process. And that doesn't mean they're going to prevail. It is possible that instead of getting 3 cents on the dollar, there will be 0, but that's not really the point here. You're losing a lot of other objectives that the law outside of bankruptcy is supposed to fill. And it becomes very easy once one spends a lot of time in the bankruptcy system that everything is about money. And I appreciate that the lawyers in this world work very hard and they talk about maximizing value all the time. But in addition to the fact that we often don't know if value actually has been maximized, that is one of many objectives of the legal system overall. And the fact that these issues are then funneled into bankruptcy shouldn't make those non-monetary objectives irrelevant. I think there are ways you could more have your cake and eat it too.
Right. So outside of bankruptcy, the plaintiff doesn't have to accept a settlement. They can just keep going. But this is really just, you get a settlement That's it. Like you don't have a choice. And so because settlement also does the same thing. Settlement truncates the discovery and everything else, which is why a lot of people don't want to settle, even if it means more money. They want to.
Well, that's the thing. If we're truly talking about a settlement, and that word sometimes is used to mean three people have settled, and we think we want to impose that on everyone else, which is how sort of what bankruptcy does. Outside of bankruptcy, there are issues in aggregate litigation, class actions, multi-district litigation. People may not always be as informed of what's going on as they should be. But take simpler scenarios. The idea of a settlement is that you and I have agency to come to the deal we decide to reach, that we've privately ordered a resolution to this, and the law is going to respect that. Bankruptcy's power, in addition to canceling debt and halting everything, especially in restructuring cases, is to say, as long as I get a majority of people on board, I can impose this result on everybody, as you were just saying. And that works well with bondholders. That works well with intentional participants in investments and in commerce, who, again, that's part of the deal they're ultimately making in their investments. And we know of holdouts. I know you've done shows on sovereign bonds and hedge funds who will chase Argentina around the world. Bankruptcy limits the ability to do that. Where I get a little concerned is when corporations or nonprofits or even governments say, wow, this is really cool. We don't have to get everyone to agree. We just have to get some of them to agree. And so then they're not traditional financially distressed enterprises, but they see bankruptcy as a really cool toolbox to resolve broader problems. And that's what I get disturbed about in the mass tort and child sex abuse context, those kind of cases, and also the civil rights in a bankrupt city, that they're being swept into a majority binds everybody system without all the values that are supposed to go along with those kinds of claims.
Well, setting aside municipal bankruptcy and nonprofit bankruptcy, which is, I think, fascinating. Chapter 11, if you have successor liability, then the whole system would fall apart. So what would be the alternative? How could you have successor liability where the buyers of the estate wind up potentially having to make additional payouts? That would seem to kill any deal. That would basically mean Chapter 11 would no longer be Chapter 11.
Right. I want to say maybe we should be careful about who gets in the front door because of the need for finality on the back end. But let me break that down into two different scenarios. The scenario I was talking about was thinking about a restructuring plan that's voted on by claimants. The company emerges on the other side. In some of these cases, it sets up a trust. First of all, those trusts are not always delivering what they promise. The track record is rocky, and Chapter 7 of Unjust Debts tries to shed some light on what we do know and also what we don't know about how some of these cases work out. And so the one-way finality that Chapter 11 brings, given the relatively high rate of plan, I don't want to say failure because that says too much, but non-completion, does give me pause about under what circumstance should that sort of liability shield be imposed right away? Are there circumstances in which parties can negotiate to say, well, maybe you should perform for 2 years? Now, I can hear the lawyers and financial advisors yelling at me saying, well, you can't do that. We need certainty in the markets and whatnot. And I'm not saying we do that in every case, but there are some kinds of deals that seem amenable to some sort of deferred complete protection, given what we know about if there are cases that are particularly likely to not fulfill their promises. But overall, I appreciate the importance of finality and the fact that the majority binds the minority or binds everybody in a Chapter 11 when all the other rules are followed. That is the law. And again, back to the sovereign debt context is a reminder of why that law makes sense. Question is who gets to use it. Now, you mentioned a buyer, and in many cases, we have a relatively quick going concern sale in Chapter 11 to a buyer who is very interested in that court order that it can't get outside of bankruptcy to do this M&A deal. But if it does it in bankruptcy, it will get a court order saying the assets are being acquired, the company's being acquired free and clear of various liabilities. Now, here I would say I'm going to get a little formalist now about how the bankruptcy code didn't really provide this track. This is one that was developed in practice and has become a very prominent feature because circuit courts have tolerated it. But to the point about successor liability there, what concerns me is that here's a place where Congress did not make clear that these sales are supposed to provide successor liability. It says, and I'll get real technical here for a second, the statute says free and clear of interests, which generally is interpreted to mean property interests like security interests, easements, covenants, that sort of thing. Claims is a whole other separate category in terms of debts. But multiple circuit courts have said, well, interest must mean claims here too. That just makes the most sense. That is not how the term is interpreted anywhere else in the bankruptcy code. And we're in a textualist, usually textualist Supreme Court world now, although it depends. And so if it is a good policy idea, then I'd like to see it more firmly embedded in the actual language of the code, because I think it has created some problems.
And of course, the most interesting cases here, it's when the claims haven't ripened yet. So you've got these companies that they're solvent, they're liquid, at least officially, but they know that they've got some bad news coming down the road. They know that there's going to be a ton of lawsuits, or at least there's lawsuits that are happening right now, but they haven't been resolved. And they have a pretty good sense that when these things do get resolved, they're going to be pretty big and they're going to cause the company to file. So why wouldn't we want them to file before these things get out of hand? Because if they can't, then all their other creditors and customers and employees, they're all going to bail out. They're all going to jump ship and the company's going to collapse. So why wouldn't we want them to nip this thing in the bud and just get it out of the way?
There is not a formal insolvency requirement in voluntary Chapter 11 precisely because, well, A, people could fight about solvency, but B, because if companies wait too long, it is more difficult to reorganize them. That is certainly true. Having said that, bankruptcy law is still the exception to ordinary law, that if all contracts could be and all liabilities could be compromised by declaring bankruptcy, then it's the same as what was argued earlier about that concern that people are going to run out after their graduation and file for bankruptcy to get rid of their student loans. That's less realistic than very profitable companies saying, wow, it'd be great to strike a deal with the claimant's lawyers who are most willing to play ball. By the way, have some of the weakest claims relative to other law firms, and put this behind us forever. So one of this is a gating issue of who's entitled to this package. But it's a delicate balance for exactly this reason, to say, if you're so far gone by the time you file for bankruptcy, then Chapter 11 can't be as helpful. But if you're a profitable company, why should you get to use the emergency kit? And what does that do to certainty and markets and the law? There is a delicate balance. Where that's been especially challenged is with cases like when Johnson & Johnson tries to resolve its talc liability in bankruptcy. And Johnson & Johnson isn't going to put an operating subsidiary in, so they create a non-operating subsidiary that could sit in bankruptcy a long time without us disrupting their other operations. And it's certainly not the only company that did that. There are other asbestos and other manufacturers who have tried this. What's problematic about it is that the whole Chapter 11 is written with the incentives of operating companies in mind and the need to move forward and resolve things to keep in business and to have to balance all of their different kind of claimants. These cases that isolate only the tort claimants in a basically non-operating subsidiary, the Chapter 11 laws as they exist now just don't function well in that scenario.
But I mean, if we look at it from the perspective of these tort claimants, wouldn't this be exactly what they would want the company to do, to salvage as much value as possible so that they have as many assets to go after? Is it really just a representation issue that whoever is representing these tort claimants, maybe they're not doing a very good job? Because if they're doing a good enough job, then they should emerge from Chapter 11 with a pretty healthy claim.
Well, against what and whom. What money has been put in the trust, the company's already clear if you've gotten all the way through bankruptcy. So you're banking on a prediction that's based on an aggregate. And then there's a process to determine who gets what. The debate has been going on a long time about how, in theory, the idea of bankruptcy sounds like it should maximize value for claimants. The challenge is when we look under the hood and say, well, how is this actually working? And also, I hate to bring up the Constitution, but is it constitutional to, first of all, let a solvent entity use all the bankruptcy emergency kit and cut off the rights of people who may not even be injured for 5, 10, 15, 20 years? It's not fully resolved by the Supreme Court whether there is a due process violation embedded here. People are acting as if it's okay, but there is some legal and constitutional risk there. The other thing, I think when we try to look at how it works in the real world, we get other complicating incentive factors. I mean, you mentioned whether lawyers are doing their job or not. I think it is more complicated than that. How do lawyers fund these operations? What kind of litigation financing deals are going on? And how does time affect the decisions that they're making on behalf of their clients because they ultimately need to close the deal because of their own financial constraints? So I think it's just a messier picture. I used to be a believer. Early in my career, I helped write a report that talked about how bankruptcy was a better option for mass torts. And that report, I was not one of the commissioners, I was just the staff attorney. But in writing this report, we did say, but we got to change the law in all these ways because right now it may not be constitutional and is not fair to different kinds of creditors. And instead, practices continued, but none of those proposals were really taken to heart. And they were certainly not adopted by Congress. So the reality is just messier. And I would just ask those who try to theorize about the role that the system plays in mass tort, think about the various moving parts and how it deviates from the model.
I know some of these mass tort plaintiffs' attorneys, and they're pretty good. They're certainly no dummies, and they're definitely not inferior to the bankruptcy lawyers, right?
Exactly. So, I mean, I think this is a really, thank you for saying that. I say this to students, I say this to anyone. Just like I can't paint all claimants with a broad brush to say, some are going to want different things than others. They have different severity of injuries, and they're just different people. The same is true for restructuring lawyers. The same is true for plaintiffs' lawyers. Now, it does not surprise me that the plaintiffs' lawyers you hang out with are the best of the best. And if they weren't, you probably wouldn't be talking about it right now. But I think the idea of who our social circle is or our professional circle and how that affects our perceptions, I think about this a lot. I think about it for myself and how who I knew would frame my intuitions about how things should go. And of course, I don't know what I don't know, and I don't know who I don't know. So there's a range of practices in the plaintiff's bar, just like there is in every other group of lawyers. And it is also depending on the size of their client pool. I know of some plaintiffs' lawyers who say they might be willing to represent several hundred, but that's already pushing it. It's one thing when you have a very specific kind of injury that happens from a product. Everybody gets the same hole in their hand. I made that up. Same hole in their hand.
Well, like Robbins was the IUDs and that sort of thing.
Robbins was closer to that. People still did have a range of reactions, but we know exactly how the product was used. We know the problems the product was caused. And so we had a little bit of a narrowing there. What I can't wrap my head around is some plaintiffs' firms are purporting to represent 18,000 different people whose injuries may vary in what type of cancer they have, how much research has been done about the causes of their cancer to the extent that can be determined, which it often can't for some. I'm not an epidemiologist, but also how strong is the argument that they used that talc and for how long? And what do they do to manage the disparate interests of their clients? That sounds really tough. I'm not saying it can't be done, but it's not straightforward that it will be in the, how do you make that in the best interest of that entire claimant group if it really does run the gamut? It's a professional responsibility question, even certainly more than an ethics or than a bankruptcy question.
Well, maybe you can walk through the mechanics of this for people who are unfamiliar. So you've got a company like a Johnson and Johnson, Manville, whatever, Remington, and they're solvent, but there's litigation that's either happening or about to happen, and they file for bankruptcy. And now the judge doesn't have a claim like with a dollar amount that they can just throw into the mix with all the other creditors. And instead, what they have to do is they have to somehow predict what the outcome of the litigation is going to be, and then assign some probabilities and then so forth. And then they come up with this number, which they then add into the mix. And then that group gets some kind of post bankruptcy claim. And it could be in the form of debt, okay, or it could be in the form of equity. And if it's in the form of equity, then that seems like they have a stake in the ongoing enterprise. So if the ongoing enterprise turns out to be super successful, then they get to profit from it. And so maybe just walk through how on earth they do that, how they figure out what this number is.
Well, there's been certainly experiments and trial and error all along the way, which would be true outside of bankruptcy as well. The difference is bankruptcy is making things super duper final. So at least the way they've structured it becomes harder to revisit some of those assumptions. So the path can depend on the maturity of the litigation, is one way that some people put it. By the time asbestos was hitting the bankruptcy courts, and that was the first test use of bankruptcy for solvent company, Manville, and then there was UNR around the same time. There had already been a lot of litigation, and there were fewer questions about whether asbestos was hazardous. That was accepted. I think the question still is, how much do you value a mesothelioma claim versus a pleural thickening claim or other kinds of asbestosis, a more general idea? And even with a so-called mature litigation, mature estimation, more information about how the severity of these claims, those trusts really struggled. And there are reports that show how far the actual recoveries have deviated from the expectation or the promise, including estimating 100% payment and then getting 7% or 13% or 20%, depending on what year one happened to get sick. So
I think you're saying it's an unbiased estimate, and it almost always results in less than what they thought.
That has been the pattern in the cases that have been studied so far. It is actually hard to get all the information, but there's
never been a fund set aside where there's like, okay, everyone's sued and now we've got money left over.
Well, the Manville Trust, there's some suggestion that's what happened in the Manville Trust. There are many books written about that case, and some of the research on A.H. Robbins. The Manville Trust became insolvent almost immediately. So they had to restructure the trust, but the Manville Company had already moved on and was into its new life. A.H. Robbins, that's the case that involved the hazardous birth control, very dangerous as it turns out. And that case is known among bankruptcy lawyers as one where they paid everybody and they had money to spare. The books that are written about H. Robbins and the birth control suggest that there was a lot of pressure on women to go for the quick pay early in the case and say, you don't have to show us much. We're not sure if we're going to have enough money, and it's going to take a really long time to process. If you want say you have a more severe injury, here's a way to do it so you don't have to worry about any of that. Lots of women chose that quick pay. It was under $1,000. And while it was a couple decades ago, there's no way that could cover if people had irreparable harm to reproduction or the kinds of surgeries that they needed to get and the like. So is that a full pay case? Some would really doubt that it is. Did the women opt in? Well, they did, but they had very imperfect information. So that is an example of that scenario. You did ask about, let me go back to your point about, you can ask it to me again about what the format looks like to come up with that number. Did you want to ask about that?
Yeah, because if the courts systematically underestimate the value of those claims, then the winners are the other creditors. It doesn't make sense to say that the winner is the company, because there's no such thing as the company. Winners are the other creditors wind up getting more than they would have gotten otherwise.
And the professionals have done very well, too. I do not want to forget the industries that both keep this system going, but also very profitable. These cases, future claims representatives, very profitable representation and the like.
Wait, do these bankruptcy lawyers, are they kind of like doctors where they, want to make sure that the patient doesn't get too well so that you can get some repeat business? I mean, is there any reason to think the bankruptcy lawyers are setting up these companies that emerge from restructuring
I
to?
wouldn't go that far. That's not something that I have said or would say. I do think it's a very profitable system and that for restructuring professionals in the biggest cases. But that's also why looking at other kinds of problems and making them into problems amenable to the bankruptcy toolbox seems attractive. I want to take some of the pressure off of the bankruptcy courts here in that this book is very much not about how they should try harder to do their job. That's not my message. I think that, so we have an adversarial court system here in America. They're supposed to evaluate the information and the disputes that come to them. The bankruptcy judges are not supposed to be in the room for the negotiations, for the mediations. They're not supposed to know the behind the scenes. So they get what's presented to them. In a lot of these cases, there's been hard-fought disputes behind the scenes where once upon a time, claimants are going to have one proposal for the value of all of their claims versus the expert for the debtor or an expert for an insurance company or the like. But often a deal has been struck before you get to the competing estimates being presented to the court. There are a lot of times a court only gets one estimate and it isn't seriously challenged. Does that mean the estimate is correct? It does not, or will prove to not be, or even at the time that some claimants would say that it was unrealistic low, for example, but then leads a company to be able to say, see, we're promising everyone 100%. So there's that dynamic. There have been some cases where judges have played a more active role in an estimation process. My own view on this is that under the structure of our judiciary, bankruptcy judges don't have the power to decide personal injury and wrongful death cases. Congress said that. So I'm not confident that bankruptcy judges should be able to estimate those same claims. But some judges don't agree with me, so they do it. But the same issues can come up with that I've just discussed. It's still based on, we have an industry that's developed to try to predict the future. And it's one thing to say, well, they're likely to be off by whatever margin, but remember that this is one-sided finality. Bankruptcy is providing an end in most of these cases to say, if there's not enough money, oh, well, it's not saying you have to put in more if something goes wrong. You could create a plan like that, but that's not what a lot of these look like. So it's an imperfect situation in that there's a lot of faith being put in the estimates. And then everyone goes on to the next case, but the claimants are left with the issue of, is this going to work how it was promised?
Yeah, I think the most disturbing part of the book was the accounts of how non-bankrupt players can have their claims, their liabilities wiped out, like the Sacklers, for instance, or the police officers in Detroit. Now, to what extent is this just simply an acknowledgement of reality? Like, if you want to get something, you got to get this deal through. There are people that are in a position to block the deal. So you've got to buy them out, right? Pay them off so that you can get this thing through. Why is that a problem?
Well, it's more recently become a problem because the Supreme Court, shortly after my book was published, held that if the Sacklers want to have relief from all opioid claimants against them that allege direct liability, that the Sacklers did something wrong to harm them, that needs to be done with consent, that it can't be imposed, that the bankruptcy code right now, what Congress wrote, does not authorize the Sacklers getting the equivalent of a bankruptcy discharge without filing for bankruptcy themselves. So that's the law right now. A lot of circuits of Court of Appeals across the country, one step below the Supreme Court, already had that ruling, and some didn't. They resolved the circuit split. Now, I've only given you the pure legal answer. The other one, I mean, is it I will tell you that this is another one where members of the general public, if you ask them what they hear about that bugs them, it is the idea of a billionaire family. Not that they can't make a deal with you, Greg, to say, Greg, this is what we will do. Are you willing to settle your claims against us? Your autonomy requires that you're allowed to make that deal. The question is, if you make that deal, can you impose it on me and a sister and someone else? And does our legal system tolerate that kind of, it's a very coercive federal power. So the arguments differ about whether people think, well, could you get more money in another context? We see a lot of different ways these things could work out. Would they have to pay more, or they're going to pay less because they might get sued by other people? Yeah, I think I would not be one who would try to predict all the ways that that can come out. I do go back to my more general principles here to say, we're talking in April 2025 right now. We have a very, very assertive executive branch who thinks there's not only that there aren't three branches of government, but that states don't have a lot of rights either, or private citizens. And the constitutional structure that we have is supposed to give states most of the power over law and enforcement over citizens. And there are specific, narrower categories of things the federal government can do. One of them in the Constitution is this bankruptcy power to force people to accept changes to their legal entitlements that they don't agree to. But how far can that go? This is a bankruptcy clause. Is the Sackler supposed to benefit from this bankruptcy clause? So any case where someone says, well, the ends justify the means because we like that this created a pot of money, we're going to find another example where people are going to hate the result. So that's a long way of trying to explain the different ways to think about that problem.
So you're saying that even if the plaintiffs were worse off, we have other objectives, right? Other public policy objectives like procedural justice and accountability that are sacrificed in a situation like this.
Well, I think our legal system requires that, to say it can't. Maximizing value, A, sometimes it's hard to prove that it's true, but B, if maximizing value were the only driving principle of our legal system, we'd see some very different things. And how far could it possibly go? We see, on the one hand, we have police brutality claimants whose claims are canceled, but we've had courts say that people with property rights who have takings claims because they think the government took some asset a particular way, those claims actually get protected in at least some bankruptcy cases. So what kind of message is that sending, that sort of lifetime bodily harm and sometimes death is overridden by only money considerations, but claims in property are different? And now I'm not arguing we should question those takings claims analysis. I'm only saying I don't understand why it doesn't apply, for example, to other constitutional claims. But our legal system does not start and end with the bankruptcy power. Bankruptcy is a little asterisk on the big legal system that we have.
Well, one last question. The Anglo-American legal system is known for its generalist lawyers and generalist judges. And so we don't typically have a lot of these specialized courts and specialized bars. And there are a couple exceptions, right? Tax, of course, but bankruptcy is one of them, right? We have bankruptcy courts, we have a bankruptcy bar. I mean, you obviously have to know a lot about the other bodies of law in order to practice. But I mean, is this a problem or is this a good thing? I mean, I think Doug Baird would say having this tight-knit group of people, all of whom know each other, they're engaged in repeated interactions, this develops some trust, it suppresses opportunistic behavior and so forth. Is there a potential problem with the insularity of this bar?
I think it always has a spectrum of consequences. That law sometimes has to be complicated, but it doesn't have to be as inaccessible to other people as sometimes bankruptcy law is. And there are plenty of other fields who have gotten that way. And we don't even see all the adjudication that happens in specialized administrative agencies because they're not as public as bankruptcy or tax. there are absolutely benefits to specialization and the trust that does develop among people. It is one of the things that has made being part, even though I don't practice, part of the larger bankruptcy world very gratifying, even though I'm concerned that the system has gone too far. But it can lead to some tunnel vision. It can lead to focus on one toolkit and the advantages that toolkit can bring over the kind of front of mind values and objectives that other lawyers would approach it with. So bankruptcy was never meant to be a system that stopped all other laws and policies and imposed only one. I think there is a way that the bankruptcy system can be useful, that these very learned professionals can be useful and will continue to be, without overriding so many other swaths of important federal policy. We're talking, these cases end up involving employment discrimination, and we've talked about the opioids. We've got customer privacy front and center with the 23andMe bankruptcy that's looking for a quick sale of the company. Pretty much every policy issue that you can imagine does come up in a bankruptcy case. And we need to couple the expertise that the bankruptcy professionals bring with the other legal objectives and make sure that other regulatory and other policy issues are adequately addressed. And if that means sharing responsibility for a bankruptcy case with, sometimes there are agencies that need to be looking at a certain problem. I mean, thinking about antitrust, thinking about foreign security issues, all of those kinds of things have to be addressed in a bank, even if the transaction takes place in bankruptcy.
Well, before I let you go, I have to ask you, do you teach the same way that Elizabeth Warren teaches? Because, I mean, I remember that was quite an adventure taking her class, because she's a very nice woman in person. And I said, hey, I'm over studying finance and history. Okay, if I sit in on your class? And she was like, oh, sure, I'd love to have you. And she had her dog there and she was very friendly. And then the first day of class, she's like, you, back row, Wharton guy, and then she asked me this lender liability case, which is the first case. And she just ripped me to pieces, tore me to pieces, made me realize how stupid I was and how little I knew. I mean, I hadn't had contracts yet or anything. And I was like, yeah, of course, case. But, lender liability is a very weird thing. So you come from the world of finance, you're like, well, this doesn't make any sense. And so I didn't have any answers. And then I was like, oh man, I really got to step up. I really got to up my game. And every now and then when I'm tempted to be that way with my students, I realize, I can't do that anymore. I can't, they'll rebel. They'll, they'll run to the dean and they'll say, don't be so mean.
Well, I think one of the challenges and rewards of teaching is creating an environment that makes them bring to the best of their ability, that they're always prepared, they're always willing to engage, and to know that that ultimately is powerful for them, that calling on people, lots of people call it cold calling. I don't like that term. To inviting people to be part of the conversation sort of very frequently prevents domination of one or two people taking over the whole class, and then gives those people more experience, also making mistakes in front of other people, not getting it right. I think the consequences of not getting it right in class should be pretty low if you've done the work. So, but the idea of empowering more people and keeping lots of people in the conversation are things that I take away from my own experience. I think I got called on pretty much every day in that class, but I don't remember it the way that you do. Maybe I was asked some easier questions.
Well, I actually enjoyed the fact that the instructor had very high expectations, and perhaps she knew that I was okay with that. So it worked really well, and I learned a lot, and I wound up taking bankruptcy 2 more times at 2 different other law schools. Melissa, thanks so much for joining me. The book is called Unjust Debts. Check it out.
Thanks for the conversation, Greg.
Thank you for tuning in to the Unsiloed podcast produced by University FM. If you enjoyed today's episode, please give us a 5-star rating and review in your favorite listening app. To listen to our other episodes, please visit our website at www.unsiloedpodcast.com.